second, environmental concerns and real property tax services. Can I get a motion to approve the minutes of our prior committee meeting, please? McGowan, Supervisor McGowan?
Oh,
Sorry to interrupt you, but one of those.
I'll
one of those
I'll allow it this time, Chairman. McDevitt.
deals. We have a motion by Supervisor Gerasi, seconded by Supervisor McGowan. We have set to approve the minutes.
Oh, yeah.
Yes.
It sounds good. Yeah, wasn't paying attention.
Any comments, any seeing none, all those in favor?
Aye.
Number one, a request to authorize the chairman of the Warren County Board of Supervisors to sign the attached release and waiver of covenant. Lexi.
Okay, so we have a resolution request here from there was a gentleman, Mr. Turner, who bought a piece of property at our 2019 tax foreclosure sale. And 2019 was one of the years with the clause in it, the restrictive covenant clause. So they are requesting to get a release from the county. And the county attorney's office had drafted up a release and waiver of covenant and real property, which you will see attached. And I believe Mr. Turner is good with being able to use that to prove that we no longer have any type of claim to their property.
Supervisor McGowan.
Yeah, so moved.
Yes. Can I have a second? Second by Supervisor Gerasi. Comments,
Thank you, Chairman. My question is for the county. attorney.
please, please.
Thank you. County Attorney Elman, is this I recall just briefly from last year, I don't know if there's a limit or a dollar amount, or if this is something that is just signed by the chair and not put before the board? Is that what our policies say? Or is it something that's signed by the chair then put before the whole board?
I don't believe there's any policy in place. This is to sign a document to clear up the title records and the title for particular pieces of property. Right now, the properties that were sold through the foreclosure, well, that became county properties through the foreclosure process and then went through auction, contained this particular provision.
So it would be signed, but it would be approved by the board to be signed by the chair.
No, I believe the resolution that's being proposed would give the chair the authority to sign the waiver and release document for any property, I think as recommended by the county attorney's office.
Do we have a policy that supports that? Or is that within the authority?
I'm gonna jump in. We just passed in October a resolution to remove this restrictive covenant going forward. So, and we also had Lou Raw come in and represent his client to have a quitclaim deed done back to them. And so instead of having to do all those quitclaim deeds back, we've come up with this release and waiver form to be able to just allow the chairman to be able to sign the release and waiver form to basically say that the county is releasing any interest that we may have held by that restrictive covenant that was in these people's deeds for those 3 years, 19, 20, and 21. This one pertained to 19. We do have another resolution following this one where we're asking to do for everybody or be able to.
There's two resolutions here. The first one is specific. I recommended that we do two resolutions. The first one's specific, right? And it's specific for that particular property for Mr. Turner because it's unmarketable right now with that deed restriction that's on the foreclosure on the deed funds property. The second resolution is a request for a resolution to give the chair the authority going forward regarding any of these, to be able to sign the waiver document so we can file it quickly, so people can move forward with the sale of their property without it having to come through committee and then to the board of supervisors every time one of these pop up. there's a good number of them out there. And it could be one next year, it could be 10 next year. I mean, this is something that's gonna go on for I think, many, many, many years. As people go and sell a property that they got through the foreclosure or auction deed rather, they're gonna find if the other party does any title work or tries to get title insurance, that they cannot.
Just a follow-up to that, will there be a report in our committee packet, much like the notice of intent to fill, that lets us know when the chairman signs these, so that the board is made aware?
That was not part of the resolution request.
I'm just wondering if there's a way to do the resolution allowing the authority to the chair, affording the authority to the chair of the board to do it, and then execute these with the caveat that whether it be at the full board meeting or through this committee, it would just be an updated item in the way that many of our other things are.
We up to the committee to make, if the committee made that decision or modification, then that would become part of the resolution. I generally recommend against it because you're gonna be dealing with these, you know, not just in the near future, but in years and years down the road. So
Really based on the,
I support your.
it's easy enough to, I guess, on one hand, to take the signed waiver and forward it to the board of supervisors. There's a way to do it. My concern is somewhere down the line, I'm not here, you're not here, we're all not here. There's still a property that's here that needs relief. And nobody remembers to report it to the board. So maybe that's another.
Supervisor McGowan.
I have to agree with my counterpart from Queensbury. It's, you know, it's really just more or less notifying us of this, really with transparency. I mean, just so we know what's going on. Is this what I'm trying, I mean, just an accountability that, you know, we're all on the same page. It's kind of a simple thing. It's not really to hold up any process or anything, but, you know, just to allow us to know that, you know, this, we've come across another one and it's been signed off. It's just something simple. So it's through the committee, so we know, you know, it can be added, simple.
Supervisor Bramer.
Thanks. I just want to bring us back to this resolution we have on the table now for Mr. Turner. I have two questions. One is for Lexi. What is the status of this property right now? And my other question is for Amanda, is this resolution going to go in front of the board? Or is this simply to authorize the chairman without going to the board?
So it looks to me as though the one that you're on right now currently, it's gonna be a resolution that goes to the board. And then the other one is a policy going forward that will also go to the board, but in the future, that policy would allow the chair to sign off those without board authority. But this one that you're looking at right now is a resolution that's gonna authorize the chairman to sign off on this release and waiver for this property. But as I read it, it will definitely be a resolution that goes to the board.
Thank you.
Thank you. That's what I wanted to know.
So currently, this Terry Turner owns this property. It's in the town of Chester. And he reached out to the county attorney's office to figure out what could be done to remove that clause. So this would be the easiest way to handle this going forward because he does.
I'm
not-
asking, I'm sorry to interrupt. What on the ground is happening with the property? Is it a mess?
Oh, I don't,
You know what, I didn't look at this, but I don't even know if it's residential, but I can look it up pretty quick. I can get to my website.
part of the issue that we identified was that that provision attached to every property and the majority of properties were vacant. So it was hard to bring vacant property in compliance with the certificate of occupancy because they were vacant. But it still was a condition that affected title when individual. As to this one particular property, I don't know what its current status is.
Is our colleague from Chester here? Around?
Maybe still, he was here earlier, but I know he is aware.
You want, Craig?
I don't know, I'm there.
Yes.
Just let me see if I can open this and I'll be able to tell you if it's vacant or. It does have a residence on it. I know the town is aware of it because I did speak with the deputy supervisor yesterday because Mr. Turner was in his office. And they were trying to figure out if anything was going on with this resolution. So I really think that if there was a problem with the property, the deputy supervisor would have definitely let me know that yesterday, but Terry Turner's property.
Yes, I
on
know.
Olmstedville Road, there's no issue with that.
Sorry, catch me with the conversation. I'm sorry.
So Terry Turner came to the county and requested to have a waiver done so he could be able to sell the property.
That's right. Because he bought it out of foreclosure.
Correct.
He did sell it, didn't he?
He has
Or
not been
it's
able
just
to
about
because he's
because of
waiting on
that.
this.
And there is no issue with that property.
There is not. It's the one on the left, right?
Just past Cafe Adirondack.
Yeah.
Yeah.
So
So when that was on the
it's
schedule.
just
look
the
that up.
residence. It's not have junk and everything all around it.
There's no
There's
zoning
no
issues and,
disrepair.
yeah, disrepair and that kind of thing.
Right, right.
With it,
Yeah.
okay.
Coat of paint.
I think all questions, I think, have been answered. We have a motion and a second on the floor. All those in favor?
Aye.
And if I just may say, Terry was able to pick up that property. I think it might have even been in his family. at
It
one
was.
time, Wasn't it?
Mhm.
And now he sold it to another resident of the town of Chester who's now able to have their own home. So it's really worked out well, one of those.
Right, wonderful. Number two, authorize the chairperson of the Warren County Board of Supervisors to sign the attached release and waiver of covenants as needed going forward for certain properties that had the restrictive covenant clause included in their deed from the county of Warren. Lexi.
So on this particular one, I took the same waiver and release or release and waiver. And I just left empty spaces for the information for these other properties going forward. It was 3 years of foreclosure sales, so I know that there's probably over at least 60 parcels that'll be coming at some point and probably requesting something down the road if they decide to sell. So, I just really think that, excuse me, this would be the easiest way to handle it. And I am willing, I mean, if, you guys want that in there, we could add something under the details of this resolution that, when, these people do come in asking for this, if the county attorney's office wants to share that with me, that information, then I can bring it to committee and at least make committee aware of, these coming through. Unless it's something that you want to go before the full board. So, but if you wanted to just come to committee, if they want to share the information with my office, we can, I'll gladly bring it to my committee meetings as they happen.
Supervisor Seaver.
Thank you. I'm inclined to move this resolution, but I would like to add an amendment or add something to it prior to the policy. And my suggestion would be to add a number 6 that just says upon signature by the chair of the board, a copy of this correspondence would be emailed to the Board of Supervisors within 10 business days. And that can either be by the county attorney's office, if they're the ones that are going to have the signed copy, which is where I think it would be appropriate. But then it mirrors, much like our FOIL policy, when there's an appeal, the board is notified. It mirrors public notices that we get, we send to the full board. And of course, it's not unlike any type of correspondence that would addressed to the full Board of Supervisors. But it does keep the board in the loop. That would be my first question. My second would just be to confirm that this is within the authority of the chair of the board.
It could be within the authority of the chair once the Board of Supervisors gives him the.
Okay.
Or her.
And do you see any logistical problems with adding that number 6 to that county attorney?
Really just was going to do it in the distant future was my only concern.
Which I'm sure our real property director would also make a note of in her internal policy as a checks and balances.
And the director of real property probably may or may not be involved in that process.
Okay.
So,
Yeah.
Supervisor McGowan.
Yes, I guess, by doing so, and allowing us, supervisors all to understand that, just to make sure that, say there is an issue in that particular town where this property is, and our chair is not aware of that, and he's signing this release, and then that supervisor comes and says, why'd you release that? We have, you know what I'm saying? It gives, if there happens to be, like we just asked, are there any problems with that, property up in Chester? We had to ask you, and, so we're not all familiar with these properties that are sold or what could have happened once they were bought at auction and how they're ending up now or selling them. So to me, it's really more of a checks and balances and being transparent. So I like option one, and I'd second that one if that
Supervisor Leggett.
is an option there.
Thank you. To go back, that this all came as an action of the board of supervisors a number of years ago, because when certain properties have come up for foreclosure, they come up for foreclosure for a reason. They're not taken care of, and they're called a nuisance within our community. So the idea was that a new person gets that, they need to bring that up to some sort of standard and have it no longer be a nuisance. So now we're seeing that there's problems that these properties cannot be sold again. So the idea is to be able to remove any of those covenants that, if there was no checks and balances on how you got these properties back up to be compliant within the 2-year term. So if we're looking to remove any of those restrictions on the deeds granted by the Warren County to the purchasers out of foreclosure, what can still affect the intent of this legislation in the first place? And perhaps it is in each town's zoning building codes to say, that property needs to be demoed. That property is a nuisance, and here's your violations, and take it from there. So I see that if the county no longer is able to enforce this legislation, and it gets removed, gets rescinded, then the county doesn't need any other notice, because it's just like it was before 2 years ago. So there is no other need for the county to know anything. It's more of a town problem. I saw that the chairman had his hand up over there.
I do. Our town brought this up in front of the real property tax to pass this, because properties were being sold at auction, sat there, nothing was done to them at a period of time. So if you remove this, it'll be up to each individual town if they want to pass a local law to put something in there for these properties. That was the whole emphasis on why this was done. It was to stop these properties from sitting there as terrible. That's what's going to happen now. It's going to go back on to the local community to do something about it.
Supervisor Seaver.
Thank you. I understand we didn't have privilege of the floor extended, and I know we're in the middle of this debate. I in no way acting county administrator Leggett, you may have walked in after I expressed the fact I support this policy. The only request I'm asking is to copy the board of supervisors after it's signed. I think we can all agree we're here as county legislators. While you indicate it would only affect the towns, our jobs here, sitting at this table, is are as county representatives for our communities. All I'm asking for is to be notified after it's been signed, sent out to the board. That's it.
Supervisor McGowan.
No, and I understand that's by allowing the supervisors to know what's going on. Like I said, if the chairman doesn't know that it's still a nuisance up there, then by notifying the board, then it doesn't get signed, and we do not lease this covenant until maybe those people fix up what they had to within the 2 years. So it's still there. It's just allowing us to know and keeping us all informed. And like I said, if this particular property was signed by the current, chairman, and you weren't aware of it, all right, and there were still outgoing issues in your town on this particular property, once he signed it, it's over and done with.
Supervisor Brand.
I just wanna, I respectfully disagree with my colleague from Queensberry that we are not giving the chairperson the authority to decide yes or no based on whether or not there's an issue. My understanding is that the amendment brought by my colleague to my right is that the Board of Supervisors would be notified after the chair signs the release. The release must be signed once we're contacted, is my understanding. Pursuant to this new resolution that we are putting forward to give the chairperson the authority to sign these waivers and releases, I support the board being given simple notice that this has happened for whatever properties they still applied to in 19, 20, 21. Our real property director can correct me if I'm wrong. I have a little bit of concern about putting that language about the notice in the release and waiver. But I want to support it because otherwise I do have a worry that people will forget in the future. So I just put it in there that we would get notice and that's that.
Supervisor Drossy.
I've lost track. I just want to make sure we have a motion to amend the resolution.
We have apparently a number 6 added after the 5 to amend. And I think the point of the amendment was to ensure that we give the full board an opportunity before action occurs to enable the full board to be aware of it.
We don't have a motion on the table. I think we were still talking about what was before us and what was being presented. And again, I think last month we agreed that something had to happen to speed all this along and to do the right thing for county and for the property owners. I don't disagree with any of that. All I'm saying is if you add it to the resolution, you add it to the contract, it's a checks and balances, make sure everybody just gets an FYI, it's not a veto. And that's why the chairman gets paid the big bucks to sit there and be responsible for whatever decision he just made. This isn't to veto that, it's to just notify your fellow elected board members.
So would you like to make a motion for that?
I would make a motion.
Well, I'll second
And
that.
to clarify, it's after it's signed.
After it's signed.
Not before.
Correct.
Right.
If any committee member wants to go through this drill,
Yeah,
every
yeah,
single time there's a property that wants to be sold, then don't vote for this resolution. The
Right.
Resolution, the purpose is to help the property owners sell their property quickly.
Quickly.
I'm happy.
So we have a motion and a second, Supervisor Brammer.
No comment. Thank you.
Thank you. Lexi.
So I think that added language should be added to the resolution. I don't think that the language should be added to the release and waiver. The language that is in paragraph 1 through 5 refers to the stuff that was in the deed that they acquired in 1920 or 21. So that's what all of that language is that's there. So I don't know if we would really want it in the waiver and release, but if we could put it in the resolution. Right. So that it was in the resolution stating that that's what needs to happen with any of these.
Recognizing
go
those concerns, what I would like to be able to do though, is at the end of it, right before in witness whereof, where it says the attached resolution, comma. And to be provided by copy to the Warren, members of the Warren County Board of Supervisors via email. By the county attorney's office, something like that. It's
The only concern I have, and I'm not a title lawyer, is that we're gonna find fault in that, because then we're gonna need proof that that occurred and question whether this document is actually effective. Absent notice to the Board of Supervisors, so you're potentially, and I'm not saying this is the case. I know there's title attorneys out there who actually do this for a living. My concern will be just like they found issue with this covenant. They could find issue with that additional language and need additional proof from the landowner that it was actually provided to the Board of Supervisors in compliance, because this is a legal document. It's going to get filed in the clerk's office. If it's in the resolution, which is I appreciate the clarification, because that's what I was mentally assuming, then we have to comply with the resolution, which we will.
my only concern is that it won't carry over and that we lose track of it. And just like a resolution that we talked about yesterday in OPEX that we have in the books that we don't pay attention to and nobody enforces. So we can have resolutions that say whatever we want them to say, it should be in the actual policy. Is there a way to just do a CC, Warren County Board of Supervisors?
Maybe Amanda could put some perspective on
I'm
it.
sorry, I was just gonna, that's in this resolution that we're gonna end up with will be a resolution. authorizing this relief and our release and waiver, it'll be essentially a Schedule A document.
Mhm.
But the resolution will speak to what it is.
Mhm.
I mean, is it acceptable if we put in there that it's to be distributed to the Board of Supervisors? Signed, it wouldn't be in the covenant itself, it would just be in the resolution, that which is gonna be adopted as essentially a type of policy.
I think it's thinking a resolution, but I think the checks and balances needs to come in the document itself, given the problematic, issues that we've had. So again, my question for the county attorney would be, how problematic, there isn't a separate policy that's going with this. So we just have this letter, unlike many other things, we'd have a policy that would address the letter. We don't have that, we're not making that, unless you choose to. So couldn't it just be a CC to the county attorney's office and to the Warren County Board of Supervisors?
Would be right under the signature line on page 2, it just says. To Board of Supervisors.
That's fine. with me. As long as the resolution stays within the 10 days.
Supervisor Bramer.
Thanks. Could something be stated by the chairperson that I do hereby certify that I have sent a copy of this blah, blah, blah to,
Because he wouldn't have signed it. He would have certified that he did it, because he hasn't done it when he signs it.
Boy, this is complicated. Simple, but complicated. But I agree with it.
Mhm. I guess if we can put
What's the
something
purpose?
right here, if you put,
So that everybody is made aware, so all board members are made aware anytime one of these releases are signed by the chair of the board.
And
Yeah.
what effect is that?
excuse me, yes,
Right.
okay, so what if we put on, I do hereby on behalf of the Warren County of Warren and pursuant to resolution blah, de blah. Waive and release, can we put something in there that says the resolution will be attached as an exhibit? Then if the language that we are asking for is only in the resolution, at least will be part of and a real exhibit A to this deed document.
Written in after 2022, which is attached herein.
Okay. I'd be,
Hopefully that resolves and I can take out the copy to the Board of Supervisors.
yeah, I think that would be better,
And then the resolution would just be specific that a copy,
yes.
in the effort that every single one of us are elected to the board to represent our constituents in our municipalities, that we would be notified of such a document being signed by the chair of the board. I don't think any of us would disagree with that.
Mm.
I hope.
There, so are we kind of all on
We
one
have
page
the-
now? Okay.
We have the motion, yeah.
We had a second.
Yeah.
We did have a second. We had some discussion and so all in favor?
Aye.
Aye.
Opposed? Very good. I'm,
For the first or the second resolution, I'm
Second.
sorry.
Okay, well, we all know about the first one, and the, hey, it's coming to the full board by resolution.
Okay, I just, wanted to clarify where we were. Thank you.
But I appreciate, Chairman, thank you for the debate on this and
Thank
the
you.
efforts for transparency and to include all of us, the 20 elected
I
members.
think the full board in all cases should be appraised.
Thank
No, no question about it. So number 3, for transfer of funds from contingent account in the amount of $500. Lex,
So moved.
first, we have a second to that. Supervisor Gerasi, any discussion?
I just double check with the budget officer if there's still $500 left in the contingency account.
Tammy,
There's $949 remaining in.
Okay. Good.
good. All those in favor?
Aye.
Opposed? Okay, any further discussion? Cover printing, the discussion on parcel 302.8.1.2.
302.8-1-2. Just so you all know, that is the Mullins property, or what used to be known as the Mullins property. I just wanted to let you know that currently that parcel has a tax sale exemption on it. So if a property is foreclosed on by the county and it does not sell, the assessor's office then puts an exemption on for it's, and it lasts for 3 years. So in 2023, on their tentative roll, it will be put back into full tax. So if that happens, then the county would be responsible for paying taxes on that property going forward. I did have a discussion with Treasurer Swan. That's what brought this to light. So since we have not sold this property and it is not for public use, is how it'll become taxable. I guess my question is, does the county have a plan for this property going forward? And I don't know if any committee members are aware of if there is a plan going forward for that particular piece of property. I'm just trying to look to save the county some tax dollar money that they will or will not have to pay. Right next to this property is the bikeway. It could be an option to request to merge this piece of property into the bikeway to have it become taxable or non-taxable. It would be exempt, sorry, fully exempt at that point. If we leave this as a standalone piece of property, I don't think anybody has budgeted any extra money to pay taxes on this. But I just wanted to bring it up for discussion so that we could try to look into what the county does want to do with this property instead of letting it just sit.
If I can may make an observation, this is an issue that unfortunately became very emotional in the past. I'm not sure why. It is a major artery and basically is the breaking point between both communities. It's a very important piece of property as far as I'm concerned. I know Supervisor Stroud has in the past sent out diagrams of what he's proposed for it to enable it to be part of the bikeway. But just on the face of it, it looks very attractive, John. And so do you go ahead, Supervisor, then I'm going to recognize Supervisor Stroud.
Thank you. I assume you'll extend privilege of the floor to him, but Chairman, I respect your advocacy, but as chair of this committee, it is my understanding that your comments shouldn't sway our vote. And while I have great respect for you, Supervisor McDevitt, and listening to your perspective on it, I have to say it may sway my vote. And as chair, I'm hopeful that you'll give the other perspective that we did have a buyer who was very interested, who wanted to pay for it, what the cost of the taxes would be. At Glens Falls at the time, had shared with us that they weren't on board with it becoming part of the other proposal, but there were other facts in this. So I respect your opinion. I'm hopeful that as chair of this committee, you will simply provide the facts to us and not sway that dialogue. Thank you.
Supervisor Stroud. Privilege of the board.
It is fortunate that we've come up with a piece of property that is ideal. It's ideal as a park and parking facility for the Warren County Bikeway. It has almost 300 feet adjoining the parkway. It is a former brownfield site that just would work perfect as a facility that will benefit the community for decades to come. Its unique location right along the bikeway also coordinates quite well with a coordinated trail system we're trying to develop. We're trying to interconnect all the trails, that including Halfway Brook, the proposed Peggy Ann Trail, the connections to the Feeder Canal Trail, the connections from this facility to downtown Glens Falls. Glens Falls is working on a connector trail going through Coles Woods. This connects well with the Warren County Bikeway. We got an offer for 18,000. Okay, well, if you think that weighs more heavily in your mind than a facility that would benefit the greater community for decades to come. I feel that the Board of Supervisors would disagree with that position as they have. Because they did pass a resolution, the majority of which said that let's go forward with looking at this as a Warren County Bikeway Park and Parking Facility and search for grant money. So in discussions with bike groups and Ethan and so forth, this is going to be part of the greater comprehensive study that the Board of Supervisors gave the approval to go ahead with. So if we've come to a point now, just because of timeliness, where we have to decide whether we're going to pay taxes or incorporate it into the bikeway program, that seems to be a no-brainer to me. Let's incorporate this into the Warren County Bikeway, and we'll continue working on the design. As Supervisor McDivitt pointed out, there is a conceptual plan that has been shared by everybody. I've also shared with you documents that show the multiple good reasons for this to be part of the whole bikeway experience in our community. And as you know, we're gaining prominence for our trail system, whether you want to hike it or bike it. And that's bringing visitors. I think we need to feed on that. And again, in talking to the residents, they strongly support this, especially the residents who live nearby. But the bike groups all support this concept. I mean, it just seems to be supported by just about everybody, with a couple of exceptions, and I don't need to mention those. Anything else? Any questions? Yes, sir.
Supervisor McGowan first and then Supervisor Bremer.
I believe we did talk how are we coming along with any of the grants?
They're currently being investigated. Ethan's doing a comprehensive study of the bike trail systems. This would be part of it. The city of Glens Falls is doing their own study. This is part of it. I've discussed with the representatives of the city. They think it's a good idea.
Supervisor McGowan, do you have a follow?
Yeah, just, I too think it's a great idea, but, to put this, burden all on the county, being at the, location that it is, it would be nice to be able to say that it's a nice joint adventure between the city of Glens Falls and the town of Queensbury. With maybe the county, doing something with the property for you or conveying it over to the town. Is that something to look at?
That certainly is something to look at, and we have discussed it. I mean, predominantly, it's a community resource. And it would provide all kinds of opportunities for multiple municipalities. And keep in mind that people that visit to use these trails don't come from just Glens Falls and Queensbury. They come from all over. As a matter of fact, the Rush Pond Trail parking area, there was a group of cars from Ontario, Canada there the other day. Because, we have received recognition for our trail system in Glens Falls and Queensbury. We want to keep building on that.
Thank you, John. Supervisor Bremer, then Supervisor Seaver.
Thank you very much. I think what Lexi said earlier, our director, is that we do not have any money budgeted to even pay the taxes on this piece of property that we currently own in a proprietary or private fashion, not a public use fashion. So I really question whether or not the county is going to have the money to do the proposal that is being presented by our town of Queensbury town supervisor. I would make a motion that we would offer this piece to sale to the town under the current formula that we usually use for foreclosed properties.
I would say, may I say you have a motion on the floor? I assume we're back to debate, so the floor is closed, thank you. And I would second, that motion with the request for an amendment, just to reflect that the town of Queensberry would have the right of first refusal within the next 6 months. If after 6 months, this isn't, we've been talking about this for years, so now that the county has paid to clean it up, to get it to this point, I think it's only fair that the town of Queensberry, and I'm a Queensberry representative, saying, I am sure that given the increase in the Queensberry taxes, people are now looking at what are we getting for this? And while they get a lot of incredible services, and certainly I appreciate the expertise from the town supervisor, I do think as county representatives for our town, we should also be thinking about, if we adopt this as a county property, we have the legal liability. We've been talking about what now the bathrooms go on. Now if there's an accident, now already we'll have the planning department involved. You know, as a county, we're now investing all of these resources that frankly, I don't want to start investing as a county. So if we could sell it to Queensberry and have the town of Queensberry pick it up and do all these wonderful things for it for that advertised price, we don't have to pay the taxes as the county, it's a burden to our taxpayers. And I think that price was something like 55,000.
It would be, well, the value is 68.7,
We had people that were
but
interested.
they offered 18,000 was the bid that came in for sale. However, with the current clause that we have, or not clause, resolution that we have, it allows the towns to purchase the property for 1/3 of the value or the outstanding taxes, whichever is less. So obviously the 1/3 of the value, I would definitely have to double check on the full value. I don't have that sheet in front of me.
What's the taxes?
Oh, they're hundreds of thousands.
Yes.
Or the taxes. So in this resolution, just to be clear, when I'm seconded by Supervisor
Like
from Glens
325.
Falls, is they either pay 1/3 of the value based on the formula or the outstanding taxes. And, you know, either way, I think that's incredibly reasonable. And then the town can continue to develop into the bike trail and all these other wonderful things, and perhaps partner with the city of Glens Falls, but it removes the county from that. And I think as a county, we have our hands full with a lot of expenses as we continue to hear. And we have a big debate coming up as it relates to the college and other increases in union contracts. This is just something that, you know, let's sell it, whether it be to the town or to a private individual. And if in 6 months the town doesn't take this up, then put it out to the public again. That's if you'd amend your resolution or not.
I don't want to put a time frame on it. I think that we need to
Never.
put it out there and we'll have to come back if the town.
John's
The
been waving his
taxes
hand.
are assessed in July. Are we in privilege of the floor again?
Wanted to add a quick comment.
Okay.
Go ahead.
Just so everyone's aware, March 1st is what they call taxable status. So if this is left alone and nothing is done before March 1st, then the county will have to go ahead with paying taxes in January of 2024. But it's usually something that is done by March 1st to change its status. So if it's not merged together, but if you're seriously considering the sale, that can happen at any time.
Okay.
Privilege of the floor, John.
Yes, thank you. And again, this is a regional facility. The poison pill idea of trying to put the burden on the town of Queensberry, I don't think is fair. I don't think it's appropriate. This is a regional facility. It's a Warren County facility. It's next to the Warren County Bikeway. I do take care of my Rush Pond Trail and the Halfway Brook Trails and the Mount Pike Trails. We do a lot for the greater community. This is just one really small thing the county could do for the benefit of the region. So I think that what makes the most sense is that we incorporate this piece of property into the Warren County Bikeway property.
Supervisor Leggett.
Thank you, Mr. Chairman. So this would follow up on that recommendation, either for the real property director or the attorney. Once this parcel is merged, can it be unmerged?
I think part of that would fall back to the town of Queensberry. And what they require to subdivide a piece of property out. So I think it would have to go before their planning board. And they would have to make that decision if you were to subdivide it back out. It can be merged per like an owner's request, as long as the town assessor agrees with that. And then after that, though, if you decide to take it back out, you usually have to go before the town for planning board approval. And then you would have to propose everything to them. So I don't know if what exactly they require. Do they require a map to do so? Or if you would be allowed to remove it as it was prior. I'm not sure. I don't know planning board rules. John would have probably a better understanding of his town planning board rules than I would.
If I may interject, I know in the town of Chester, we have merged two people, person has two lots.
Okay.
So for taxing purposes, they had no plan to sell or develop, and they're taxed as one. The time comes and they go to the town assessor and go, can we divide these back out? And it's the nod from the assessor, because it's never been.
No.
No deed has ever merged them as one lot.
Party comments here, John.
Wow. We'll check on that.
I-
Well, I just need to repeat that. I'm not even sure why there's some dissension. This seems to be clear that it's a current regional, it'll be a regional asset. It'll be a wonderful regional asset desired by residents and visitors. And so we just merge this with the Warren County Bikeway and let's go forward. For decades, this will be a thing of beauty. It's in a great location. You can't beat the location. So like I said in the beginning of my discussion, we have a unique, wonderful situation. We should take advantage of it.
Thank you, John. Supervisor Seaver.
I just, my preference honestly is the board did vote at one point to sell this, to put it out. We had an offer for the 18,000. Now we are now looking at the fact that we have to pay taxes on it. Again, I'm opposed to the county taking this on, as we've seen just the legal liabilities on some of our county owned property in the last year, which is going to cost us a lot of money. We have a parking lot already close by it. I have heard from Queensberry residents, as a Queensberry representative on the county board, opposed to this. And, I think at the end of the day, my preference would be go back to the guy for the 18,000 before we have to start paying taxes on this and be done with it. As one supervisor from Lake George said, he would not spend another dollar of county money on this project. And he was adamant about it at a board meeting. This has been discussed extensively, but I do not want to have to pay taxes on this.
Supervisor Bramer.
Thank you. I disagree with my colleague from Queensberry about the sale to the private person before we give the town a chance to
Fair.
take ownership of this piece.
That's fair for the 68.
No, my motion is to go under the current formula, which would
Okay,
be a
sorry.
third of the assessed value.
That's fine. I won't. I'd second that.
Supervisor McGowan.
I've stated this in the past on this property, and really the only thing that concerns me, and really more of the involvement of the county, is we're good to tear that building down to the ground, but the foundation and the slab is still there. In the environmental reports, as long as they stay undisturbed, all right. As soon as we do that, there's gonna be another environmental study. So if is that fair? And that's why I was hoping maybe we could find some grants and some other money and make this a joint effort between, maybe the county, the town, and the city. I agree with Supervisor Stroud, that it is a great location. It is limited to what we can do. I do sit on the planning board. I understand the limitations that will come with that property, but my main concern is my two highest bills in this county are my school bill and my county bill. And now now seeing the increase in the town bill, it makes me concerned. So, more of a joint effort. I do believe the concept and everything is great, but either if we could find some money in that, but put the burden on more of the county, I don't know, especially with the cleanup efforts that the possibility of lingering.
And let me, I'm getting a little confused in this whole issue. So what is the, we have a motion to do what now and a second to do what?
My motion is to offer the property for sale to the town of Queensberry at the current formula, which I believe would make sense to do the third of the assessed value.
Third of the market value.
I'm sorry, third of the market value.
So if our last cash offer on the property would is $18,000, have we established, does that establish the market value of a third of $18,000?
No, what we typically use on these sales is what the state says the full market value is. I just don't have that number in front of me because I didn't think to print that screen. So, but it's, I think, really close to the 68.7.
Wait, so we've had a very healthy discussion. We're getting into the weaning hours here. So we have a motion on the floor and a second. All those in favor?
Aye.
Aye. I'm opposed, so I'm gonna vote no.
I'm gonna abstain.
You're gonna abstain.
I gotta think this out more.
Okay, okay, so the motion has failed. Lexi, anything further? Good.
There's one more item under referral. So this is something that came up at the committee, I think it was last month. Under referrals, which is the foreclosure properties that file an order to show cause with the courts and how to handle them. I know you guys had wanted to speak with the county attorney about this. Robert was here at the time, so County Attorney Elman is here. And I believe is willing to address this.
I'm not sure what the question is, so I'm going to have to present what the concern is. That'd be good. Because I know we addressed this.
Supervisor Brammer.
Well, my question was about the properties that were in the foreclosure action or proceeding, whatever it is called. And then there were, some of the property owners filed motions to get out of the foreclosure. And it's my understanding that stipulations were signed, they weren't judges' orders pulling them out. And, my question was as to whether or not the county board of supervisors should have been authorizing the stipulations, withdrawing those pieces of property from the foreclosure or not. And if we did need that, should we retroactively approve those stipulations?
I think the best way to approach this might be through education and not to take for granted that the county does this year after year after year, meaning the tax foreclosure process. So if we start at a very base level and we look at state statute, Article 11 of real property tax law for the state of New York. It starts by laying out some definitions that are used for the purposes of Article 11. And Article 11 is called Procedures for Enforcement of Collection of Delinquent Taxes. So it covers some of the prerequisites to starting the foreclosure action, what the timetables are before you start that and file that petition, how you go about the redemption process and payment process, and then provides you all of the process and procedure that's required for purposes of going forward with the tax foreclosure lawsuit. I'm going to stop there and then go to the very end, just to make sure there's no misunderstanding. The end of the process is not the auction. The end of the process is not the auction that occurs every year. When the auction occurs, what's occurring is the county has already taken title to particular properties. And they're now, through the statute, using this process of auction to the highest bidder. So let's kind of, with the end point in mind, the end of the foreclosure process is a judgment that's issued by the court and signed by the judge. And that judgment directs the person who represents the county which is our enforcing officer under the statute. An enforcing officer is the county treasurer for purposes of the county. To then deed by treasurer's deed to the county and from those individual owners title to the properties that were approved by that judgment. So when we look at the beginning, the client, the person who under statute has the sole authority for starting the action and then being directed by the court to complete the action is the enforcement officer. The enforcement officer is the county treasurer. In fact, there's a provision in one of the sections, I think it's 1166, but I might be wrong on the number, where the statute actually provides the county the ability and right under the statute to sell and transfer titles to the highest bidder after an auction without any further approval or authority by the Board of Supervisors, which is different than what the practice has been in Warren County. So by statute, the individual who's authorized to start the action, to run the action, and to finish the action is the enforcement officer, who's the county treasurer. Concerning the motions that were filed, my office, me specifically, communicated with the county treasurer about those orders to show cause. We had an attorney-client conversation, which I believe also included the director of real property, on what the strengths and weaknesses were of the individuals who filed those orders to show cause, which is just another fancy word for a motion. And what proposal was being made as a way to resolve that order to show cause, which was agreeable to the county treasurer. And I believe, I don't want to speak for the directors here, but I believe the director as well, based on all of those legal factors that we reviewed. So it was the enforcement officer that made the determination, because he's the individual, because it's a he currently, the treasurer is the individual who's authorized to start and run the action and to also remove properties from the action as the action goes forward. So it's not, by statute, it's not a process that involves the Board of Supervisors. It involves the county treasurer as a result of that position being the enforcement officer for the county. I know I didn't clearly lay that out when it came up at the Board of Supervisors maybe a month or so ago, but I didn't know the issue was going to come up then either. So.
I thank you, County Attorney Elman, for that explanation.
So I mean, just to finish the last concern, I'm 100% comfortable and confident that there is no remedial action that the county needs to take regarding this year's foreclosure action. It's done.
Just on that, this is no remedial action. It sounds like going forward, we need to do something again with our process. We tried to do this when I was chair of real property several years ago, and it was, I think we need to revisit that.
I'm not sure what
Well, it sounds
that is.
to me like the whole last chance thing is not something we should be doing.
Oh, absolutely, 100%. There's the way Warren County has developed the practice of doing tax foreclosures deviates from the state statute. It deviates in a consistent way, which means it's okay, but there's some, it's not ideal, but it's not violating the law. But there's some particular steps that occur that clearly I can't seem to ground in the statute. One of them is the last chance meeting that occurs after the redemption date.
Mhm.
Redemption date means that's it, it's over, you're finished.
And it's not in our hands, it's the treasurer.
And after that redemption date, there is this meeting that occurs with a certain section of supervisors that then hear applications to either delay or move forward despite the fact that it's occurring after the redemption date, which is again, the date, the last date to redeem the property. So by law, this was my first year through the process. I was very grateful throughout the process that the work with the director of real property in discussing some of these items as they were popping up. And my hope is that I've been saying this for a couple of months, to be able to put together a proposal for the Board of Supervisors to consider so that in a future year, we can flip back into what the statute provides as far as the timetable rather than the timetable. We have had some very good, practical and legitimate reasons many, many years ago. But maybe aren't as compelling today as they were back then.
Thank you, Larry. Any further discussion or comments?
Just-
Yes,
Are we in privilege of the floor?
we're about to, yes. So no further comments on that, privilege of the floor.
Thank you. No, again, on that, just thank you for that explanation and maybe we can look at that going forward. I know that the prior motion I made about this Mullins property failed. I just want to circle back around to that because knowing that the taxable date is coming up, try again to make this motion to offer to sale to the town for 18,000. Our bid. That would make people on the committee comfortable to move forward with that before the end of the year, knowing that we don't have another committee meeting.
I'll second that.
Okay, so we have, go ahead.
Thank you. I think if it's the town's intent to prioritize and preserve this piece of property in Queensberry, then it only makes sense for it to be in Queensberry and not have all of the county residents shoulder what could be some potential burdens. Even though we have such an incredible trail, we do have adequate parking, we do have a lot of things right around there, and the county has already paid so much money to get this property ready for sale. 18,000, I know is what the offer was we had from a private citizen. While it wouldn't go back on the tax rolls doing it this way, at least it would be in the town of Queensberry at a very reasonable price to the town. And they would then be responsible for them, it's right in the town, the maintenance and the liability, and it wouldn't be a gift, which we've been learning a lot about gifts to the town or to the city. So I would support that motion.
Can I have Amanda make a determination on that? We've had a motion previous, had a second, voted on it. Now we're coming back. Is that appropriate?
Well, you're the chair, so that's your call. I mean, the motion is changing from a third of a value to $18,000. So that is a substantial change, but that's your call.
Okay, yeah, so that's fine. Okay, so we have a,
Yeah, Mr. Chairman.
yes,
But perhaps we should ask if that is a legal thing, because we do have that process as Supervisor Bramer had pointed out. A third of the value or the amount of back taxes is what's on the books right now. So to deviate from that, is that possible?
What's a? Can't give an answer off the cuff here. I'd have to go back and look at.
What's
the statutory.
third of the value?
Third of 68.
Third of 68.
22,000, looks like, right?
Can we make the motion for 22,000, then it's a third?
Or just say,
Right.
make a motion for a third of the value instead of an actual dollar.
Okay.
say that again.
That is the motion that was made.
I will just a point of order, recognize that yesterday, for ACTAX tabled a motion, and then in the same meeting, untabled the same motion, and
Took a vote on it.
took a vote on it, and then passed it. I mean, some of that I want to follow the rules, and I think that if we say it's 18,000 and recognizing that we're requesting to deviate from that third for the benefit of the town, which of course, if our county attorney determines that that's a gift of the 3,000 and unreasonable, it would default back to the formula. But either way, it's an incredible value, and with the record sales tax and odd tax monies that come into all of the municipalities we've been hearing about, I'm sure the town of Queensberry would be happy to invest in that if we're not going to put it back on the tax rolls, which is frankly where I would be, but I would support that here today.
Larry?
I can't give an opinion on it off the cuff.
Okay, I personally, I feel uncomfortable with an attorney not giving us an opinion.
Could he just have the information available to us by the time of the board meeting?
Yeah. I can
Sure,
absolutely
sure,
do that.
sure.
I mean,
Let's
my-
do that.
my
Ask that today
understanding
and
is-
he says yes or no.
Let's do that. Yeah, that makes sense.
Okay.
Is that okay with everybody?
That sounds good.
Okay, very fine.
Okay.
Yeah. Privilege of the,
Okay, call the vote.
You have a motion on the floor to offer to the town of Queensbury for $18,000.
Subject to.
Subject, you can-
Attorney approval
Would you like to vote on that?
or
okay,
alternative.
okay. We have a motion and a second. All those in favor?
Aye.
I,
No, I'm voting no.
That
Everybody
passes.
has to vote.
That passes.
Okay. Can I get a motion to adjourn? Supervisor Seaver and Supervisor Bramer, thank you.
Thank you.
I.
Aye.